All right, so remember last class period we talked about, we finished talking about due process of the law, which we get due process of the law from our Fifth Amendment right that no person shall be deprived of life, liberty, and property. That was extended then by the 14th Amendment to all states. And if you recall, now we're going to be talking a little bit about what equal protection of the law is all about. Equal protection basically comes from the 14th Amendment. No state shall deprive any person with its jurisdiction of equal protection under the law. Well, this takes form by first determining which class or group of people are affected by a particular rule. And so the law separates these classes into three different standards of review, of which strict scrutiny would be the highest level of scrutiny. And that's really how the courts will really look at a case, how closely the courts will look at a case depending on the severity or a particular class that's affected. And then you have the intermediate scrutiny, and then really rational basis of review. Basically, if there are rules in sport, for example, that affect a particular class or type of person, because of who that person is, courts will look at these situations or rules more closely. So, for example, highest standard review, a rule that's put in place must have a certain level of rationale, a very compelling or necessary rule for the government to uphold that rule if it impacts a certain class of people. So, for example, we've been talking a little bit, well, even in our current day, there are some states that have brought out the National Guard to keep people in their homes. Well, that would normally be depriving people of their liberty interest, but given that the coronavirus, for example, has such a important governmental interest at stake, that rule is a compelling governmental interest which would allow the government to have people stay in their homes. Likewise, search and seizure concepts that we talked about last class period as it pertains to travel, so on and so forth. All right? There needs to be, for a strict scrutiny rule to be in place, there needs to be a compelling governmental interest. All right? So, the suspect class, a class that's affected by this highest standard of review, are classes that deal with race, national origin, or alienage, foreign domicile, where someone was born. The reason why these are classes that are protected with such high scrutiny is, when you think about it, none of you can change the color of your skin. None of you have a choice of where you were born. And none of you can determine who your parents are. These are things that are outside your control and really make you who you really are. So when there are rules put in place that discriminate you because of these issues or these concepts, equal protection of the law statutes then kind of are triggered, and so the courts really look at these rules that are put in place that might be discriminating against you simply because of things that you cannot control about yourself. All right, so for intermediate scrutiny, the middle level of scrutiny, the government has to show that the challenged law, rule, or practice is substantially related to achieve an important governmental interest. The class here is considered a quasi-suspect class. It's a sliding scale. All right. The more important and closer the individual's interest comes to the specific constitutional guarantee, the greater degree of judicial scrutiny. Oh, and by the way, I want to pause here and make sure that you are looking at the proper slides. This is still under Constitutional Law 1, these particular slides, all right? All right, so this quasi-suspect class tend to involve gender and legitimacy of birth topics. Now, what's interesting, since the Obama administration, the Equal Rights Amendment and the Obama administration has kind of changed the whole gender topic to has elevated the gender issue to a suspect class. No longer is it quasi-suspect, it is now a suspect class, in part because the LGBTQ group has now been qualified into the suspect class area. All right. Now, finally, the rational basis review is the lowest level of equal protection. Scrutiny is applied to all groups that are not suspect or quasi-suspect. Basically, the rule needs to show that the challenged rule of practice is reasonably related to and achieve a legitimate outcome. Okay, so here's just a quick slide. The next slide is really a way to categorize them in each category, and we're going to move on to search and seizure concepts. Okay, so search and seizure comes from the Fourth Amendment. Really, it's your right to privacy. Although the word privacy is not found in the Constitution, you do have a right to privacy based on the Fourth Amendment. It reads the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by an oath or affirmation, and particularly describing the place to be searched and the persons and things to be seized. So, absent probable cause, there should be no reason why someone should try to intrude upon your privacy. Now, interestingly enough, in the modern world that we live in, many of us give access or open the door to all of your life and habits and searches on, for example, on the internet. Oftentimes, we give up this right to privacy, when we accept apps and we blindly say, yeah, go ahead, you can have access to my pictures, access to my websites, access to wherever I maneuver digitally. When we accept our apps, we don't realize that we do this, but if you look through and you're actually to read the fine print, that's what you're doing. You're giving access. You're disqualifying yourself from some of these privacy issues. However, on a larger scale, for example, a police officer can't come to your home and say, hey, can I come and search your house without your permission? Unless you give them permission. Oftentimes they'll ask. And if you say yes, they're going to be able to search your home without probable cause. Otherwise, they have to have probable cause, and if you say no, they have to go back to a judge and ask for a warrant. And in that warrant, they have to ask for specific areas of things that they can search for in your house, unless you've given them probable cause, unless they think you've committed a crime or they have a reason or a rationale that you have committed a crime. Okay? So the starting point here for the Fourth Amendment to be triggered is a state action. And then what constitutes a search? All right? And is the search reasonable? Where this lands in sport in particular is the idea of drug testing. Drug testing is a form of a search. The courts have deemed drug testing is a form of a search. So when drug tests are done, oftentimes what people are looking at is, okay, is certain kinds of drugs that have been ingested or taken into a body, but there's so much more that can be looked at through a urinalysis, for example. A urinalysis is you can see if somebody's diabetic. You can see there's a whole bunch of other health issues that one can determine. So there has to be probable cause and a reason for a drug test to be mandated by a school or sport organization or whatnot to determine what's the reason. So there's got to be substance, and there's got to be the process in which it's done are all important. So what is the reason for the search is the key question. All right. So there has to be a reason from the inception of the drug testing. Why? What's the purpose? And then there has to be the process, the due process in which it's done is also very, very important. When we read in the University of Dearden and the Vernonia versus Acton case, you're going to come to some really interesting implications of what search and seizure is all about.